Hello, everybody. Welcome to Law and Society. Please subscribe. Today, we're going to talk about Jack Smith's final report and reports and what is happening with releasing of those reports. Now, the DOJ has confirmed that it intends to release the January 6th case report to the public. But Donald Trump, in a case, in the Mar-a-Lago documents case, uh, his co-defendants uh, don't want the Mar-a-Lago or the January 6th final reports to be released to the public because they will somehow influence the cases that are still pending. Now, Donald Trump doesn't want to see any of these reports, these final reports, come out to the public and, sort of tell the whole truth about what Donald Trump did by way of, you know, Jack Smith's final reports. Now, something that I have sort of an issue with, and I would, if there are people who, I'm sure there are people who have the answer to this question, but factually speaking, the Mar-a-Lago documents case and the January 6th election interference case, other than Donald Trump being named defendants in both of them, there really is no connection in the cases. There's no crossover of evidence. There's no nothing. And both of those cases have been dismissed. But the Mar-a-Lago case was dismissed by Eileen Cannon, and that appeal is pending in the 11th Circuit. And then the DC case was actually withdrawn and dismissed by the DOJ, and Judge Chutkan sent an order dismissing the case. So that case was dismissed and has not been appealed, and that case is done. The Mar-a-Lago documents case, as it pertains to Donald Trump's co-defendants, are pending appeal in the 11th Circuit. In this emergency motion to stop the release of the final Jack Smith's final reports, the 11th Circuit ruled both on the report of the Mar-a-Lago documents and the January 6 documents. And the DOJ doesn't seem to want to distinguish between those two reports for some reason. And the 11th Circuit has now come out and said that in favor of the government, but has delayed the issuance of the final reports until Sunday, presumptively so the Supreme Court can take it up. Now, the question again is, how does the 11th Circuit, without adjudicating the facts of whether the two final reports are related, other than just that they have defendants Donald Trump, if they're in any way similar factually or not, and they're not. And the January 6th interference case was dismissed by the District Court of Columbia Judge Tanya Chutkan, and any order that pertains to the release of the final report by the DOJ about that case should be brought up in the District of Columbia instead of the 11th Circuit. So my question is, why is DOJ not making that distinction, and why is the DOJ not pushing forward with the release of the January 6th report? Because there was no motion made to the DC Circuit, Appellate Circuit, or to the District Court Judge Tanya Chutkan, and then if that was denied, to the DC Circuit to stop the release of the January 6th final report. I don't know why that is, and if you have the answer to that question, please comment in the comment box. So that's where we are with the reports. The reports must, I believe, in my opinion, I believe that Jack Smith and the Department of Justice have nothing stopping them from releasing the January 6th final report that has already been finished by Jack Smith. And the 11th Circuit erred by including the January 6th release and staying that as well. And I know that Merrick Garland's DOJ is not going to be provocative and release them before Sunday. And so the Supreme Court, if it takes it up, it's going to rule on both of those together. And it may choose to delay the ruling on that. So the stay remains until Donald Trump gets to office and then releases them. But, the Supreme Court's timing is the Supreme Court's timing. But the question is that what's important is that the January 6th report is released to the public, because it is a case of public interest. It is a case that one of the charges was conspiracy to deprive American citizens of our right, of our vote. Therefore, we have a public interest in knowing what the full facts are about that case. And DOJ has the intention of making that public. And that case has been dismissed and is not pending on appeal by other defendants. And therefore, there's no jurisdictional issue with the DC Circuit. There's no case pending. And it is a solely executive purview whether they want to make it public or not, because that case is dead. That case is not related to the Mar-a-Lago case, but that again would be too aggressive for the Merrick Garland DOJ. So I guess we now have to wait and see how long. Whether Supreme Court puts on the stay. If Supreme Court does that, it would just be another black stain on the Supreme Court, and it would just be unnecessary encroachment on the executive branch's authority over what it does with its own final report, over which the DC Circuit does not have any jurisdiction because there's no case or controversy. And the 11th Circuit sure doesn't have any substantive jurisdiction over that. And so why would you stop the release of that? Why would you create that disbalance and encroach into the executive's power of deciding when it wants to and what type of report it wants to release? So with that, this is sort of one of those question-answer things. I welcome anybody's logical conclusions. I also welcome any expert who knows the answer to please answer my question about why a distinction is not being made on the two reports, and whether DOJ should take the case to the DC Circuit and ask the DC Circuit for an immediate release of order to have the release of the final report. I don't see where the judiciary even comes in the regard of the January 6th case, because it's dismissed and it's out of case. There's no case of controversy. There's no prejudice that may happen. And what is the logic? There's no evidentiary sort of backing behind the logic that the January 6th case would somehow negatively influence the two pending cases in the Mar-a-Lago case. There's no substantive showing of that. Eileen Cannon seems to think there's substantive showing of that. 11th Circuit doesn't. And if you give Eileen Cannon enough credence by having the Supreme Court say, yes, she's right, we're going to put a stay on it, well, there goes the judiciary. And I hope that doesn't happen. With that said, thank you. Please like and subscribe, and I'll talk to you soon.